Exactly. My people. Thank you.
I said stand in, but.
Yeah, I mean, I assume he's not gonna object to the waiver, but I believe he is speaking to the witness, so
Right.
if we're gonna waive, I don't think he needs to grab her.
So we need to do like think that.
I actually didn't do anything. But growing up, my sisters and I, we all did like Irish step dancing and played Irish music.
Oh, really? Cool.
None of my mom's generation played music at all, but they all made us do this as children. They had like their little, it's like their dreams coming true.
You're right.
Having a little family band.
Isn't that cool?
So we used to do lots of like.
That's great, that's great.
Okay.
Mr. Doherty? Mr. Doherty, you want to
So I, Mr. Doherty and I. Do you have any objection to the waiver?
Oh, okay. Calling case number 2055962, the people of the state of Michigan versus Dion Doherty. Defendant is charged with count 1, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams. Count 2, operating license suspended, revoked, denied, habitual offender, fourth notice. This matter is scheduled for examination.
Good afternoon, Your Honor.
And good afternoon, Your Honor. Neighborhood Defender Service, I Kate Demott Grady, 83667, on behalf of Mr. Dion Doherty, who is with us in the courtroom today. Mr. Doherty, can you please state your name?
Dion Doherty.
Your Honor, I've spoken with Mr. Doherty about his right to a preliminary hearing and the evidentiary standards that the prosecutor would have to meet, and he is choosing at this time to waive his right to that preliminary hearing and be bound over to the circuit court.
Do you have any objection? No, Your Honor. Thank you.
So you have a statutory right to preliminary exam where the state must show by probable cause the crime was committed and probable cause you had something to do with committing that crime. You understand that?
Yes.
Anybody promise you anything or threaten you in any way, but you waive your right to preliminary exam?
No.
You're waiving your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
All right, and you signed the waiver of examination form?
Yes.
All right, court of violation freely and voluntarily waive your right to preliminary exam as found over the County Circuit Court Criminal Division for arraignment on the information, which will be April 8th, 2021, 9 o'clock a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Okay, see you later.
Oh, I know.
You know what he's doing? Take care. Mr. Sinclair.
Okay. Yeah.
But
Oh,
he's with his class. I told him that he had to talk to him, going to talk to him at 2 o'clock. He was around talking.
oh, well, is the prosecutor here on that one? That's a different prosecutor.
Sure, sure. Is she on?
It's Mr. Nelson.
Let's see if he's outside.
Yes. Good afternoon. AP Richard Nelson here on the 2 o'clock exam, Jones and Young.
All righty. I guess everybody's here.
Thank you, sir. Good afternoon, everybody.
Thank you, sir. Very well, how are you?
I guess you're next.
Hey, Mr. How are you doing?
I'm a little tired, but I'm okay. What about you?
Always tired these days.
Oh, yeah.
Busy man.
For sure.
We ready?
Yes, ma'am. Ready, Mr. Nelson?
Yes, ma'am.
Hey, I'm you.
I was answering through you.
I'll just play around.
Calling case number 2061010. The people of the state of Michigan versus Ashley Jones. Defendant number 1 is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, weapons, firearms discharged from a vehicle causing injury. Count 4, weapons carrying concealed. Count 5, weapons, felony, firearm. Count 6, weapons, felony, firearm. Count 7, weapons, felony, firearm. The people of the state of Michigan versus Patricia Young. Defendant number 2 is charged with assault with intent to murder. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, weapons, firearms discharged from a vehicle causing injury. Count 4, weapons carrying concealed. Count 5, weapons, felony, firearm. Count 6, weapons, felony, firearm. Count 7, weapons, felony, firearm. This matter is scheduled for examination.
Good afternoon, Your Honor. Richard Nelson Jr. on behalf of the people, P 78306.
And good afternoon, Judge. I'm Christopher Sinclair, here with on behalf of Patricia Young and Ashley Jones. P number is 80512. Today's date and time set for preliminary examination. Defense is ready to proceed.
All right. Mr. Jones, state your name for the record, please.
Ashley Jones.
And Ms. Young, state your name for the record, please.
Patricia Young.
And Mr. Sinclair, can you put on the record that they're waiving any right to, in regards to conflict of interest?
So we did at PCC.
I want to do it again. I want to keep it clear because
Yes, sir. All right, Ms. Young, you do know that I'm representing you and Ms. Jones at the same time. Is that correct?
Correct.
Okay, you know that sometimes cases arise and there's a conflict between the positions of the two of you, or a conflict that I had in representing both of you, right? So are you okay with me going forward and representing both of you? Okay? Ms.
no, wait. You are waiving any potential conflict that arises.
So waiving any potential conflict, basically means the same thing really, but the magical words are, you're waiving the potential conflict of me representing both of you, right? Okay, Ms. Joe, you heard all the questions that I asked Ms. Young, right? If you have any answer that's different than hers, and you're waiving any potential conflict that comes with me representing both of you? All right, thank you.
You gotta talk.
You gotta talk.
You can't just shake your head. You have to say yes. Well, I couldn't hear you.
Oh, yeah, I say yes.
Okay, so do I need to ask all the questions again?
The last one, I gotta get that one over.
Okay, are you waiving any and all potential conflict that comes with me representing both you and Ms. Young?
Yes.
All right, thank you.
You have a seat.
All right, you ready to begin?
We are, Your Honor. I would just ask for mutual order of sequestration. I know COVID has kind of already done that, but we are broadcasting on YouTube. If anybody is viewing on YouTube that might be a witness, we would ask that they tune out at this time. I would also ask for an exception from my officer in charge, Officer Stephen Townsend, who is in the courtroom.
Any objection?
None?
All right, any witnesses testifying today at trial or any future hearing must leave the courtroom, YouTube, or nobody else on Zoom right now. Or be denied their future testimony, with exception to the officer charged, and call your first witness.
Thank you. The people will call Miss Dominique McClure. Thank you.
You all right? You have a recommendation? Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put it on right here, George. Ms. McClure, you're gonna be asked a series of questions. First by the prosecutor, then the defense attorney will probably ask you some questions, and I may or may not ask you some questions, all right? You have to answer all your questions out loud, verbally using words. Just can't shake your head or say, say yes, no, whatever the answer is, all right? Also, when you ask a question, I need you to answer that question and stop. If it's a yes or no type question, just say yes or no. If they need additional information from you, they'll just ask you another question, all right? We all have a tendency when we're talking about something, especially that may have been traumatic to us, we tend to ramble. We'll say this happened, and this happened, and this happened, and this happened. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision, okay? I know nothing about this case. All I know about this case is the defendant's name and what they're charged with. Now I know your name. I get all my information from what happened in court, one question, one answer at a time. That way I can understand, okay? All right, thank you. Great to see. Oh, one last thing. Because of the mask barriers, it can be very difficult to hear. I need you to please keep your voice up. You can, that microphone right there, you put it down a little bit, okay? That will help amplify your voice.
Okay.
All right, thank you. May proceed.
Thank you. Would you say your name again for the record, please?
Dominique McClure.
And Ms. McClure, I'm going to draw your attention back to September 20th, 2020. Do you remember that day?
Yes.
And at some point that day, in the early morning hours of that day, were you at 20315 Dresden in Detroit, Michigan?
Morning?
I'm sorry?
You said early morning?
Early morning?
No.
No. Would that be late evening then?
Yeah.
Okay. Had you been to a club that night?
Objection, reading.
Your Honor, I'm just trying to create a little bit of a foundation as to where we were and exactly what time we're talking about.
All right, this meeting right now, since it doesn't specifically go to Ellen, I'm gonna allow that question.
So were you at a club that night?
Yes.
What club were you at?
Stay for lounge on Hulu.
Okay, and who were you with?
I was with my sister-in-law, Clarissa, my niece, India, and it was my cousin, Manisha.
Okay. And how late were you at the club?
We was there about 1:30.
1:30 in the morning?
Yeah.
And then after the club, where did you go?
To Clarissa's house,
And what street is that on?
Dresden.
And is that in Detroit?
Yes.
Wayne County?
Mm-hmm.
Okay.
Is that
So,
yes?
Yes.
So backing up and getting to the club, do you see anybody here in the courtroom that was in the club that night?
Yes.
Can you point to that person or persons and identify maybe an article of clothing that they're wearing today?
The one right here with the mask on, she had on the Lakers jersey with the Lakers hat. And Patricia, she had on lime
What's,
green.
what the, what do you, well, first one, what is she wearing? Now,
She had on the button up. Light blue button up. And then light blue button up.
Okay, so we'll stop there. So Your Honor, please let the record reflect that the witness has identified defendant number one, Ashley Jones. And then you mentioned the name Patricia. Do you see Patricia in the courtroom?
Yes.
And can you point to her and identify?
She had on lime green.
She had on lime green that night. What is she wearing today?
She had a button. Black jacket.
Your Honor, please let the record reflect that the witness has identified defendant number two, Miss Patricia Young. Thank you. Now, these people are both wearing masks, as we all are. Is the mask hindering your ability at all to recognize these people?
No.
You mentioned Patricia by name. Do you know Patricia? Do you know Patricia?
yes or no?
Yes,
Did you know Patricia before the night of September 20th?
yes.
Now, you said you saw these two people at the club.
Yes.
What club were you at?
Stay for lounge.
Was there any interaction
Hold on,
that
you said state fair?
Stay for lounge.
State fair lounge.
and you said you saw these people at the club. Did you have any interaction with them beyond just seeing them?
No,
Did any member of your party that you were with have any interaction with them beyond just seeing them?
at that point, I was sitting at the bar, so I didn't see them have any interaction in the club.
Okay. Was there any drama at the club?
My niece, India, her friend was yelling, saying like,
Objection to what they said.
well,
Can't say
She was
what-
yelling.
Hold on. Go young.
That is a little bit of hearsay. We'll work around that, Your Honor. Without saying what anybody actually said, was there some yelling going on?
yes,
And who was yelling?
her name is Cheyenne.
I'm sorry?
Cheyenne was yelling,
And Cheyenne was a member of your party?
yes,
Do you know who Cheyenne was yelling at?
yes.
Who was Cheyenne yelling at?
She was yelling at Ashley.
And that's Ashley Jones.
No,
Do you know what they were yelling about?
no,
At any point, did that yelling progress to a physical confrontation?
no,
At some point, you left the club, you said.
yes.
How much later in time did you leave the club versus when you heard that yelling?
Like 30 minutes ago.
Did the yelling have anything to do with you leaving the club?
Yes,
Why did you leave?
because I knew it was gonna be something going on.
You knew that there was going to be something going on.
Yes,
What did you suspect was going to go on?
Objection, speculation. Speculation.
I'm sorry?
This is about speculation.
Sure. You left before something happened.
yes,
Okay. And did anybody leave with you?
yes.
Who left with you?
My sister-in-law, Clarice,
And did you leave in a car?
yes,
Whose car?
mine,
Just your sister-in-law with you?
yes.
Where did you go?
Yeah, okay.
Now, before you got to her house, did you see Ashley and Patricia outside the club?
Yeah,
Where were they?
I saw Ashley getting in, like a black jersey.
I'm sorry?
I saw Ashley getting in like a black jersey.
Okay. Did you see Patricia?
Yes,
Where was Patricia?
she was getting in, Malibu, like a black Malibu.
Now, you had mentioned a few minutes ago what they were wearing on that particular night. What was Patricia wearing on that night?
She had a Lakers hat with a Lakers jersey
Was that Patricia or was that Ashley?
No, Patricia.
Okay.
I mean, Ashley.
Okay, so Ashley had on, I'm sorry, you said a Lakers,
Ashley had on a Lakers hat, the Lakers jersey,
okay. What colors are the Los Angeles Lakers?
purple, yellow, and black.
What color was the Lakers hat that you saw?
Purple,
Okay, so it was, am I to understand that it was primarily purple or yellow?
purple.
Okay. How about the jersey?
The jersey was purple.
And you said you saw Ashley get into a journey.
Mm-hmm.
Did you see other people in that journey?
Yeah.
Did you recognize anybody else in that journey?
As far as like if I know them, no. It was people in the journey, so, yeah.
Okay. And then you, when you saw Ashley get into that car, what position in the car did she get into?
She got in the backseat.
Backseat on the driver's side or passenger?
And
You also mentioned Patricia that night. What was Patricia wearing?
she had on long green.
Lime green, as far as her clothing?
Yes.
And you said you saw Patricia get into a black Malibu?
Yeah,
What position did Patricia get in?
the driver's seat.
Was there anybody else in the car that you saw at that time?
Yeah.
Did you recognize anybody that you knew?
No.
You said you and your friend, I'm sorry,
My sister-in-law.
your sister-in-law went to Dresden.
Yes.
How long did it take you to get from the State Fair Lounge to Dresden?
Like, about 5 minutes.
When you got to Dresden, did you see either of those cars that you just mentioned, the Malibu or the Journey?
No.
When you got to Dresden, was there anybody else there?
No.
What did you do when you got to Dresden?
When I got to Dresden, and I pulled in the driveway, I called, Clarice told me to call the
Objection, speculation.
One moment.
I'm sorry.
What's the objection?
She said, somebody told her to do something. Well, that's what she started saying, but whenever somebody else told her to do, that would be hearsay.
No, well, someone, she could say someone told her to do something. She just can't say what that is. What that is hearsay.
Right, so
Your Honor,
based on what she was saying, my impression was she was about to say what somebody else said outside of the exception that allows for, instructions.
Your Honor, I argue that it's not even hearsay. Hearsay is a statement, like the sky is blue, it's a statement of fact. What she's saying somebody told her to do, telling somebody isn't a statement of fact, it's actually a command, much in the same way that a question is not hearsay.
But it's still an out-of-court statement. So the actual statement is hearsay. The fact that someone told her to do something is admissible. But what they told her to do is not.
Okay. What was, so somebody told you to do something.
Mhm.
What did you do as a result of somebody telling you to do something?
I called her.
And who did you call?
My niece,
And why did you call India?
this is Tuesday.
Did you speak with India?
Yes,
Did India arrive at the house at some point?
yes.
Did anybody else arrive at the house?
A couple of cars.
At this point, how many people do you think are at the house?
Probably 15.
And where at the house are you? Are you inside the house or outside the house?
I was outside.
And what time of morning was this?
At that time, it was probably like 1:50.
1:50 in the morning. So, you said there were about 15 people. Was there anybody else outside of those, say, 15 people with your group of friends? Were there other cars or other people in the neighborhood? Anything else that you saw?
Yeah.
Who or what did you see?
I seen Patricia Ashley drive by.
You saw Patricia and Ashley drive by.
Yeah.
And how did you recognize that it was Patricia and Ashley?
The Lakers hat.
Okay. What car were they in?
Malibu.
Were they both in one car?
Yes,
And you said you recognized them from the Lakers hat.
Yeah.
Is that the same Lakers hat that you saw earlier that night?
yes,
And is that the same person wearing that Lakers hat?
yes,
And that was Ashley?
yes.
And where was she in the car that you saw?
The driver's seat.
And you said you saw Patricia?
Yeah.
Where was Patricia in that car?
The passenger seat.
Front passenger seat?
Yeah.
Was there anybody else in that car?
It was a third person that I could see.
Excuse me, I can't do what you
There was another what?
It was a third person, but I didn't see who was it.
Where was that third person?
In the back seat on the passenger side.
Now, as you're standing on the front porch of that house, say, and you see this car come up,
fast out here, but she never testified she was standing on the front porch of the house.
okay, as you're facing the street,
Objection, she never said she was facing the street.
You asked what she was doing and where she was at. You are.
I'm trying to lay,
Suggesting, let's just present the fact. that happened.
I'm trying to lay a little bit of foundation about where she saw this car.
Oh, she can do that. That's the reason why you were out there
All
approximately
right.
150. Where were you and what did you see?
You said you saw this car pass by.
Yeah.
Did this car pass from your right to your left or your left to your right?
From my right to the left.
Okay. And what side of the car was closest to you?
The driver's side.
And who was driving that car?
Ashley.
As that car passed from your right to your left, what did that car do?
Donut.
It did donuts, like spinning around in the street?
Yeah.
Did that catch your attention?
Yeah.
Why did that catch your attention?
Because it was speeding and everybody was outside arguing.
Everybody was outside what?
Arguing.
Who was arguing?
When the car sped down the street and get a donut, Ashley jumped out.
Ashley jumped out.
Objection, that's unresponsive. The question was who was arguing, and I didn't hear your answer.
The unresponsive is,
I'm sorry, can
unresponsive would be his issue, not yours.
You said Ashley jumped out of the car, and did you hear anybody say anything?
No.
Did Ashley say anything?
Yes, but I didn't hear.
Okay. What happened after Ashley got out of the car?
She was yelling and jumped back in the car.
What did she do after she jumped back in the car?
You said yelling and jump back in the car?
What did she do after she jumped back in the car?
She turned the car around and went right down the street.
Back the way that she came?
Yeah.
Did you do anything after that?
Yes,
What did you do?
I turned around
You turned around?
Mhm.
Why did you turn around?
and I was getting my kids out the house.
You had kids inside the house?
Yeah.
Did you see that car again?
No,
Did you see Ashley again?
no,
At any point, did you hear gunfire?
yes,
When did you hear gunfire?
Judge, I'm late, but that was a leading question. I asked the court to strike the answer.
Yeah, it was legal. Meaning suggesting fact, not evidence.
At any point, did you hear anything?
yeah.
What did you hear?
I heard gunshots and like it was burning rubber from a car.
Okay, so I want to make sure that I've got the timeline correct. You saw the car do donuts and then go back to the right.
Mhm.
You turned around.
I turned around.
Did you see that car again?
No, I just heard the gunshots and the burning rubber.
And was that gun, how much time passed from you hearing the burning rubber and seeing that car to hearing the gunshots?
Honestly, 3 to 4 minutes.
3 or 4 minutes?
Let me turn it around. I'm getting ready to walk towards the house. And I heard the car burning rubber.
Objection,
and
this is the
gunshots.
narrative.
Your Honor, that was like 3 or 4 sentences strung together.
I'm gonna take the answer.
So, I'm sorry, please continue. You said that you heard the burning rubber and you turned around. What did you do?
I was walking towards the house.
And how long did it take you to get from where you were when you heard the burning rubber to the house?
I didn't get a chance to get to the house
Why didn't you get to the house?
because no shot.
From when you last saw the car that did donuts with Ashley driving and Patricia in the passenger seat, from the time that you last saw that to the time that you heard the gunshots, how much time do you think passed?
Objection, asked and answered.
No.
He asked that question, I wrote down the answer, so it's already been asked and answered.
Well, then,
No,
could
because
you share the
from the
answer
time-
with me? I want to make sure that,
I wanna make sure, I think he asked a different question. The first time he asked, when she saw Ms. Jones jump out of the car and was yelling, get back into the car and drive off, she said, when did you hear the gunshots and the burning rubber then? She said, that was 3 or 4 minutes later. So.
What's the new question? Maybe I heard the question wrong.
Yeah, repeat your question, so I'll make sure. I get it.
the question that I asked was, from the time that you last saw that car and started walking to the house, but didn't get to the house because of the gunfire, how much time passed?
I don't know.
Objection, that's the same question, Judge.
That's not a different question. I'll
It happened real fast.
allow it. So anyway,
It happened real fast? Okay. Did you see any other cars?
No.
How many gunshots do you think you heard?
Like
I'm sorry?
3 to 4 gunshots.
And you said, you used the phrase, you got shot. How did you find out that you got shot?
Because I felt it in my heart.
You felt it in your arm?
Yes.
Where in your arm were you hit?
My right arm.
Your right arm, and for the record, you're motioning just above your elbow?
Mhm.
Did you
Yes,
get hit anywhere else?
yes,
Where else did you get hit?
in my leg,
Where on your leg?
right under my thigh.
On your right thigh?
Mhm.
Was there anybody else outside?
Yes,
Who else was outside?
my cousin Manisha.
What did you do after you found out that you got shot?
Well, actually, I didn't know. Like, when I felt it, I thought that I was, it just wasn't my parents. And I was walking towards the garage, and my cousin Manisha helped me get her. She said, I'm shot. And I'm like, I'm not shot, she's like, you are. And then when I felt the pain, I ran in the house.
After you ran into the house, where did you go?
To get my kids.
Did you get your kids?
Yes,
Did you seek medical attention?
yes.
How did you, where did you go to get medical attention?
I drove home, and then my girlfriend Charlotte took me to the hospital.
And at the hospital, you got attention?
Yes,
Now, I just want to, did you see who shot you?
no,
Did you see the car that shot you?
no,
Did you see any other cars out there?
no.
When the shots were fired, did you hear anybody say anything?
No,
No further questions?
Got 1 second here?
Sure.
All right, no questions, Judge.
Thank you. We can put that.
Your Honor, with that, the people have no further witnesses.
Ben?
No witnesses for defense.
Your Honor, the people would make a motion at this point for binding over on all counts. We did hear from the complaining witness that 3 to 4 shots were fired from a car that was occupied by both the.
No. That is not what we heard.
Correct. We heard from the victim that, or I'm sorry, the complaining witness, that 3 to 4 shots were fired shortly after. She initially said within minutes, but did clarify that to say that it happened very quickly. She wasn't even able to get a matter of steps from where she was to inside the house. She did testify that the defendants were at the same nightclub earlier that night. There was an issue that was about to happen, so she and her friends decided to leave. The defendants followed her to that house, or at least were, maybe not followed, but were at least seen at that house a short while later. And the defendants stopped the car. Miss Ashley Jones got out of the car and was yelling something unheard at the direction of the complaining witness and her people. A few moments later, the car drove past again, and mere seconds after that is when 3 to 4 shots rang out. She did testify that there was nobody else in the area that she saw, no other cars, no other people, other than the people that she was with and the 2 defendants. So, Your Honor, with that, the people do feel that there is sufficient evidence to create a question of fact for the jury.
Judge, I object to the bind over on this case because to me the most important testimony is she said she didn't know who shot at her, she didn't see who shot at her, or anything of that nature. She also testified that there were I think she had either 15 people or 15 cars that were around at the time she left the State Fair Lounge and got back to her location. And again, she didn't see who shot, she didn't see a weapon or anything of that nature, so there's nothing connecting her being shot to my client specifically. And the court is not able to use like speculation or guessing to tie in gaps of missing testimony or assume that Ms. Young or Ms. Jones was involved in something just because pursuant to the witness's testimony that they were around with these 15 other people at the time where something happened at this address. There was no testimony that there was a disagreement between Ms. Jones and or Ms. Young and the complaining witness. The witness just simply said there was some stuff going on at the club, and at some point she decided to leave. And kind of along that same line of thought, when she got back to the Dresden residence, something happened, shots were fired, but she received who did it, or she doesn't know who did it. So we can't, it's not enough there to say that my client shot her. I'm asking for dismissal on all counts.
Just briefly, Your Honor, as Mr. Sinclair points out, the witness did testify that there was something happening at the club, but she doesn't know who exactly it was directed to. And then there was something that happened, some animosity that happened, some yelling that happened at the house involving the same people that were at the club. And then just mere seconds after that, 3 to 4 shots rang out. It's true that she didn't see, but she did testify that there was nobody else out there, nobody else with any animosity. She was with 15 people at her house collecting her kids. These were all her friends that were out there. There was nobody else out there other than these 2 defendants that clearly had some issue with, if not this complaining witness, some of the people that she was with. So, Your
I
Honor.
know that they were all her friends that were out there. It's not the testimony.
She was collecting
She
her
said
kids.
there were 15 other people, when they made that phone call, there was these 15 people out there, and they were out there yelling. And she said there were other folks from the neighborhood out there. That's the testimony. I wrote down.
She said that there were other people from the neighborhood?
Yeah, he said, yeah. Was there anybody else out there? She said, yeah, there was some people from the neighborhood. Okay. All right, anything else?
No, Your Honor.
Before having heard the testimony and arguments filed at the file, September 20th, 2020, late evening, that the witness is coming to the floor into the state chair lounge. She was there until approximately 1:30. Right after she went over to the house on Dresden, took her approximately 5 minutes to get there. She saw both the defendants, Ms. Jones and Ms. Young, at the club. But there was some kind of incident that happened at the club, where either her cousin or one of her the people who were with her was yelling at Ms. Jones. As she left the club with Clarice, they saw both defendants outside the club. That saw Ms. Jones get into a drain, the backseat passenger, and Ms. Young was the driver of a black Malibu. Pulled up over on Dresden. She ended up calling, I don't know if it's a relative or friend, India, who came to the house. There was about 15 people out there at least. We saw the defendants drive by. She recognized the Lakers hat in the Malibu, recognized Defendant Jones as the driver, and Young was the front seat passenger. The third person in the vehicle she couldn't see. Car did donuts in the street and then drove back down the other way. Well, the donuts, then Miss Jones jumped out of the car and was yelling something, but she couldn't hear or understand what she was yelling. Initially, she said 3 to 4 minutes later. She then changed that to say it was relatively soon. After she was walking from in front of the house up to the house to go get her kids, she heard gunshots and burning rubber. She heard 3 to 4 shots, and she was walking. She got a shot in the right arm and her right thigh. She didn't see any other cars. She ran into the house, got her kids, drove home, she went to the hospital. She did not see who shot her. She did not see another car in the vicinity or where the shots came. She didn't know. She didn't know. She was very honest. You know, and I have to commend her on her honesty. But the point is, even for a probable cause hearing, you know, the dots have to be connected. There's nothing to say that one or both or anybody in the car that these women were in, they go down the street, had a gun. I don't have anything. I have nothing associated them with guns. I have nothing associated them with shooting. They drove back off. As far as I know, they drove off and kept going. You know, anybody. It could have been somebody in that 15 group started shooting for whatever reason, and they accidentally shot Miss McClure. I don't know. You know, and I can't, and I'm not allowed to speculate. I'm only allowed to infer based on the facts of evidence. I can't infer that these two women did anything based on these facts. So as such, the court's going to dismiss.
Thank you, Mayor.
Thank you, Your Honor.
Did you have a thing?
Excuse me. Let him get his word down. We got cases.
How you doing out there?
Yeah,
Mr. Chestnut?
for,
The next one.
yes, Ms. Young is out there, that's what I said.
Can you put this on?
For him? Sure.
Oh,
Hold on just a second. Actually, Ms. Sinclair.
Yeah.
Hi, good, how are you?
Very well, thank you. I was moving like 0.3 seconds.
It's no, all right. All right.
Yeah, it's simple out, please. I wish you did about actor.
Yeah, Mr. Gaines.
I'm moving. Close that up.
That's Michelle.
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 Judge, I've had a great day. My first case I had this morning, held the exam, dismissed. This case, held, dismissed. I got like, where your face? I got Facebook postable material now.
Maybe one day I need that bracelet.
Listen, I can't, listen. I ain't about to fool with you.
a nice seat cushion right there.
Oh, no. I'll get that for you. Yes. Now I'm hot. Oh, it is.
Mr. Sinclair, let's only say that. It's good to feel good about it. Oh, please don't put it on Facebook.
Don't put on.
No, do
I gotta put too much stuff on Facebook.
What's the process?
I don't,
Yeah, don't do that.
Richard Nelson.
Richard.
What you, it's like advertising, you say the charges and dismissal, and then like everybody goes, oh, you're so good, you know. I don't put names.
How you doing? This is Derek.
I'm probably talking too much.
Hey, give me a favor, still. I'll put you on hold just in case. Derek.
Okay. Okay, and then I'm on hot. I just learned that my graduating.
I got work the. That's good. I get paid.
So let me see if I had a question for you. So with those orders of petitions and everything that the other people.
Yeah.
I just want to.
Oh, that's right, they both got some.
Yes. This is black diamond. I think.
On the chestnut matter,
Yes.
I didn't have anyone check in. I called it, I said, is anybody here on the chestnut matter? You called again? The real chestnut?
Sure. I'm gonna go sit down.
Have a nice cool drink, just to relax.
Oh, some Gatorade.
Yeah, that's what I'm talking about. That'd be cool, especially on the tea.
Oh, yeah. Somebody asked me if I drink, I said, no, I'm crazy enough without count food.
That's good, that's true. Hey, you got something.
I'm gonna have a new suit.
You know what?
I said, I can go have a new suit.
Oh,
I'm like, I just got some Christmas things in my book.
that's how you do
I don't know if I'm supposed to do that.
it. Say,
Sometimes people volunteer. Thank you, man.
yeah.
You're in.
That's good.
All right, bye. See everybody.
You ready on Chestnut? Calling case number 20-60260, the people of the state of Michigan versus Terrell Chestnut. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Alex Curry on behalf of the people, Your Honor, key number 84950.
Good afternoon, Your Honor. Neighborhood Defender Service by Elizabeth Young, appearing on behalf of Terrell Chestnut.
Ready to proceed?
No, Your Honor, actually, our witnesses did not show up. According to the file, it appears that subpoenas were indeed done and sent on December 21st, and yesterday, reminder emails were sent, and to my knowledge, and to the, I believe the court officer knowledge, neither the OSC or the testifying witness are here.
Move to dismiss, Judge. Thank you.
Mr. Chestnut, you wait for your attorney.
You get an order right in the middle at the bottom.
You know what?
What if what?
We were ahead of the game.
Dismissal order.
I already took care of it.
Oh,
Yeah,
wow.
that's
why she was there. You were like,
call it.
They should put one more copy on this.
Yeah.
I have to make a copy every time.
Well, he loved this. Do you see Mr. Nelson in your office? Is he-
Oh,
Oh, I see.
thank you.
Mr. Nelson,
Thank you,
is he in your
Thank
office?
you.
Take care now. Mr. Nelson,
The guy who was here before,
Yeah.
am I seeing him?
do you see him in your office?
No,
Okay.
no, I think
Because
he's
he
on
left the
11.
sheets, that's all I said.
Oh, okay, I think he's on 11. Okay, I'm upstairs.
Oh, well, he left here. It's here.
He's in the office.
You want all this?
Yeah, just keep it, because. Here. Yes, sir.
Sean?
Maybe he's not gonna refile it. I don't know.
I know that's right.
Gaines is here. Is the attorney here?
Ask Mr. Michon, come in, please.
Counsel?
I still have not mastered the eyeglasses with the mask,
I know.
let alone the dangly earrings.
Yeah, you gotta put them through.
Oh, it's trippy, all right.
I think what, yeah, what?
How you doing, Ms. Michelle?
How are you?
We ready on Gaines?
Yep. Make it stop.
Calling case number 21-56313, the people of the state of Michigan versus Ronald Gaines. Defendant is charged with count 1, robbery, armed, habitual offender, for notice. This matter is scheduled for examination.
And good afternoon, Your Honor. May it please this most honorable court. Kim Shaw, Neighborhood Defender Services, on behalf of dear Mr. Gaines.
Judge, at this time, is the date time
examination. I do have a detective Terry in the courtroom with the officer in charge. However, I do not have my complaining witness. We have made efforts to contact the individual. As far related yesterday afternoon, you tried also. Okay. Can you explain to the court what happened 2 days, sir?
What's your name correctly? Detective Lewis Terry, directly. I called, Mr. Savage multiple times. I didn't get in contact.
Okay.
And with that, the defense would move to dismiss, Your Honor.
Sentence, your sentence.
Oh, you don't.
Okay.
Just let them get. Oh, yeah. That's why we asked. And I am sorry, my friend, I do not have a case number. I apologize. My hero. You lucked out. She's fantastic.
I had a beggar to come work for me.
That is not true.
They said you were too mean.
Oh.
I'll try to do better.
There are days you can be a grizzly bear and days you can be a teddy bear.
I guess.
I'm giving a call. Yeah. It's cover ready.
Hey, Blair,
Yeah.
I was very interested as to whether or not your 19-year-old was going up to be, that he was buying an iPhone 10 for $200 cash on the down low. And usually runs
100?
And we're headed to Mr. Gaines.
or more.
More like 600.
Yes.
If it's refurbished, maybe 5.
Yes, depending
But
on
if
how
it's
you
new,
get
it's
right.
like 6 or 7.
Yeah, I know there's about 700 or so.
Yeah, the new one is like
Yes.
12 is over 1,000.
Yes.
Like 11, 1200.
So I'm like, oh, we got shady,
Yeah, what's somebody else?
shady.
That's what I'm trying to think this one. Is it?
Exactly.
That's
That
true.
would be Yeah, but what happens is that
That's the prosecutor.
they update all the iOS stuff.
Yeah, well.
How many times you can give me that?
You can't replace the battery.
How many times you can give me that?
Thank you, my dear friend.
Better replace the battery.
What was that?
I said back years ago, you used to be replace the battery.
Yeah.
So if you keep your phone for 3, 4 years, just go buy a new battery.
Exactly.
Now, they caught on to that.
You got out of business, huh?
So, yeah, no. Make sure you can't replace the battery.
Wow.
They have to refurbish the, that's not how they refurbish the phone, they got to put the battery.
Okay.
Interesting.
Yeah, that's good. Yeah, mine, I have to take the battery out.
A lovely day. I guess that's all the trouble I can cause you.
Okay.
You must leave now, Ms. Shaw. Okay, good.
Good, Giles.
That's it.
Yeah, I'm on.
And you wrote.
When I get it. When I get all the paperwork out.
So nice out now, like.
What else you can say? It's supposed to-
Right,
VANIELLE.
You said
Now?
I believe so. It didn't look like you need your story.
724
Okay.
925 6655.
I'm just waiting for Mr. White to come out. Mr. White. Mr. White.
All right, how you doing there?
Yes, it is.
Yeah.
It's very hot here.
I know,
Yeah.
we're also.
It's nice
We ready?
outside.
Hold on till I get him on.
Oh.
They brought, came, they got together.
Okay. All righty.
Don't you say that! You're gonna get me in trouble!
Okay.
You see that white little dot right there? Stuff where you- You said that.
Blair, are you waiting on witnesses or?
Okay, you said-
Yeah, he's in the hall.
Oh, I think, the one on the record, you would like.
What's that? Normal size cake?
Yeah, it's like, you go down,
Okay.
and then they said they were saying that you had a really.
439.
We have verification of it now.
Okay. It's pre-trial services. You should have it. Just, mine's on automatically in. Yes, PTS badge and be at Federal Circuit. Yep. At CC. You're welcome. We ready?
Yeah.
Calling case number 2156243, the people of the state of Michigan versus Clifton White. Defendant is charged with count 1, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Count 2, weapons carrying concealed. Count 3, controlled substance, possession. Count 4, count 5, weapons felony firearm. This matter is scheduled for examination.
Good afternoon, this is Oscar Glenn. We've been playing with this Officer Giles in the courtroom.
Good afternoon, Danielle Federici, 77162 on behalf of Clifton White. Same name.
Clifton White.
All right, thank you. Ready to proceed?
We'll have our witnesses here ready to go.
So I'm not ready to proceed. I was sent discovery from the prosecutor, paper discovery, I think twice. Both times, for some reason, it was shrunk way down. I sent an email to Karen, I'm probably pronouncing her name wrong, Gagnier, on March 11th, saying Can you resend this as a regular sized document? I can't read it. It's really small. When printed, it looks like it was photocopied on a large background and on another background. And then she responded and forwarded it to someone named Jacqueline Rice, who said, since it appears you redacted and uploaded this discovery, is there anything you can do to help? And she never responded. And then this past Friday, I had an email exchange with Matthew Stoloff from the prosecutor's office. And I said, I've received 3 copies of his paper discovery. However, each of them are the same and too small to read. I don't understand why the copies were shrunk, but to ask him to send me a full-size discovery or a full-size document, but I had not received any video discovery. And that I have no idea why that happened, but I can have it resent, and I never got it. And I still don't have the video. So I'm asking a motion for dismissal based on lack of discovery.
Judge, just in response as far as what we have said, we said it 3 times, March 11th, March 17th, and March 19th. If this category has a copy of what we have here, I'd like to see the size of it, because what we're showing here at evidence.com, it seems to be normal size. Computer is, I don't know what you got, and whether it's reasonable or not. With the video, I don't have any indication that there's been any video uploaded to the system at all. Pass along. I'm not, I'm sorry, defense counsel. And that we do not have. That I cannot.
Also, I forgot to, Judge, I also started resubmitting the request through the prosecutor's website with notes on there saying, need video, and I'm still not getting my discovery.
My understanding is that with this going back to paper, Judge, that apparently it can be zoomed in on when it is received and it was successfully sent 3 times.
She didn't say the paperwork wasn't, she didn't say the paper discovery wasn't sent, she just said it's with me. So, I wouldn't necessarily dismiss for that reason, but the video wasn't sent either. This is from March 2nd. This incident is, 2021.
I'm looking at the officer who's standing here beside me, looking at his report, he's looking also. It was body worn camera indication, it doesn't have anything out there. It's just not known down here, so. Then I can't explain it, maybe. Why, I don't know, but there's nothing in the body worn on this.
I'm worth this over one time. I want all discovery given to her, including video, if it's not in the I'll put it over. I'll put it over one time. I don't want it.
Also ordered them to give me a full-size, the full-size page because I can't read what they're sending me, and when I print it, I really can't read it.
Judge, my understanding, we're right here with the computer, you can zoom in on it when you receive it through evidence.com. I don't know why it's not working for this kind of array.
Well, it's not. I don't know why it's not working, but it's.
That, I mean, if we're making it available to her, I can't.
Okay, Mr. Moody, at this point, I'm made my room. It's not a debate. It's really not even a discussion. I want all discovery provided, including video. I'll give you a new date.
Okay. I would ask that if Ms. Canary wants to set up an appointment to come to our office to view it, if we can't get it to her, those emails don't go to the prosecutor, so I don't know where she's sending it to a discovery person. So I can't correct that. I don't know what it is. I don't know how to get into the system to do that. But if she wants to set up an appointment to come down to the office and view it that way, there's no problem with that.
I'm done, his, I'm looking at his folder, his paperwork right there is in normal print. I don't know why he can't just make me a copy instead of making me, because I'm pre-approved to get the discovery that he is required to give me.
This paperwork was downloaded and sent, the same, I don't know what goes on with the computer at this point.
I understand that, but you can just take that paperwork and print it off and make a copy of it, and she'll have it. And then all she needs is the video at that point.
Okay, we can do that. Now, I don't know if we can do that now here, or did you want us to be in our office and have it up, or whatever?
Well, if you want to, if you feel comfortable, we can do it right now, right here.
Yes, let's say you wanna send it to me and then I'll print it.
Can I do what?
If you send it to me, I can print it.
Oh, from this?
Yeah, if you're gonna send it to me, to send it to my email and I'll. print it.
Yeah.
No, see, listen, he has the same thing I have. When you print it, it's real small. So, the prosecutor has in his actual folder, normal size paper. So that's, if you could just, print, like, copy that.
Oh, I mean, I can do that too.
Okay. That's fine.
Because I did print it, I just you can't read it when you print it. Listen, I emailed it. Listen, I'm frustrated with how many times I have to beg for discovery, not just on this case. When I have to spend 3 different days and then keep thinking about it and keep wondering where it is so that I can review it before I get here, it's unnecessary. And, you're causing me anxiety of, like, what am I doing with this case? And I have a hearing coming up. I emailed a copy of what it looked like. No one in your office is responding.
I don't have a copy of it.
3 different?
I understand your frustration, Henry, because we have it on the opposite side, but we said it 3 times.
Okay, so,
And defense says they don't have it. It's the
listen, if I can
same
just
thing.
get a copy of what's in your file.
I don't have a problem with that, okay? But I would like to see that so I can take it to someone and just show them.
Right now, can we get a copy so we can give it to her?
April 14th, 2 o'clock. Work.
Thank you.
Yes, it does.
We only have one witness on this, right?
Yeah, Judge, we do.
Someone come up and give it to pick up Mr. Watson. 2 more minutes.
You're right. There's no one I did. Which one you at? Did you say or did you what? You don't know which one?
You got it?
I think so. It goes face up. Up.
Yeah.
You're going?
Yeah,
putting that one?
I just printed some.
All right. Okay. Noting on the record, Judge, if we can hear all the discoveries that we have as far as paper goes, we'll be looking at the video. All right. Ms. Cattery, did you acknowledge receiving that on the record?
ID as in David. IA dot ORIEL at 36. No, at.
What's your fourth page? This one came out blank.
What page?
The fourth page?
Four?
Yep. Maybe it was just
Four.
a slip up on the section.
Yeah, it's 36 TH
That's what that was.
District Court.
No. Yes. Yes.
So this fourth page
What's
was
it in between?
blank.
You're welcome.
This is blank.
What's the page before it?
This one, page 3.
The request for this one? Yeah.
Okay, then this was
That's an added
it's
page.
a 3 piece of paper.
Right.
Okay, good. All right,
Okay.
thank you. Thank you, everybody else too.
All right, we're finished? Yep, we're done.
Oh, okay. Thank you.